4 panel just as they were leaving that I wished we could have had this conversation with them, because I have a feeling it's going to bring some really interesting and divided opinion. But the way the day is structured by time, we're only getting to this story now after the panel has left, and I didn't want to steal any thunder from our guest or from the story itself. This goes to Bruce County, or as I like to call it, Cottage Country, because that's where our family has cottaged for many, many years. And it takes us back all the way to 2006. That's when 2 teenaged boys tried to steal vehicles, unlocked vehicles, in the village of Paisley. And they found such a vehicle at an auto shop. It was there for repairs or whatever. And the keys were in the car. The boys subsequently crashed that car, seriously injuring one of them. And a jury found that the auto shop was partially responsible for the injuries that occurred in this car crash because they left the car unlocked with the keys in the ashtray. I find this a little difficult to digest. The Supreme Court is mulling it over as we speak, but is yet to arrive at a decision. Nick de Koning is with Deutschmann Law and takes time to join us for a chat. Nick, really appreciate your time on this. Thank you.
Oh, I'm very pleased to be on your show, Mike.
So what would the jury have based its decision upon all of these years ago, that a garage where the car was stolen from could somehow be at least partly liable for this crash?
Well, I think that what this is first of all, this is a very, very, very sad case. I think it almost underestimates the description of the injuries to say this young man was seriously injured. I think it's horribly, catastrophically injured. The trial was in 2014, and the plaintiff is referred to as JJ in the decision because he was only 15 at the time of the accident, unable to testify some 8 years after the accident, and from what we can gather of the decision, probably requires round-the-clock care years and years after the accident. So I think what's going on here beneath the surface is this is kind of an insurance-driven type of proceeding, because if there was adequate, the typical auto policy will have a $1 million limit. Even with a stolen vehicle, there's an absolute minimum limit on the stolen vehicle on the auto policy that would insure the car that would have been about $200,000. So, one would only see a plaintiff lawyer reaching as far as this garage, seemingly rather creative kind of case, to make in a scenario where they're trying to access some insurance. And so probably this is the only insured defendant at this point in time. But so what it is in my view, would be sort of a conventional application of the law to a rather strange and unconventional type of situation. But basically the law of negligence deals with claims based on people's carelessness or failure to take care to protect other people. And the key elements of negligence are foreseeability and proximity. Foreseeability in this case was driven by the very kind of unusual facts of the case, and what we had here was a garage that had a business practice of basically having no security and no care taken in terms of safeguarding, at any given time, a number of different vehicles on their property.
And so is the key here that lack of security and the ease with which the vehicle was stolen? I'm trying to think of this, Nick, in terms of my own driveway. If my car is locked and somebody breaks into it and takes off and gets into a crash, am I going to be held liable? Or because my car was locked, I'm kind of off the hook?
In my opinion, you as just a regular citizen, in your own home or your own driveway, you're not responsible in that scenario. And in fact, the Court of Appeal, so keep in mind where this proceeding is at, it's with the Supreme Court of Canada right now. The appeal was heard in October of 2017. We're about 6 months beyond that. We're waiting for their decision, and that's sort of a typical time frame. They average about 6 months on decisions from appeals. So the Court of Appeal, though, which is the highest court in Ontario, before it gets to the Supreme Court of Canada, they say that right in their decision. Well, this is not a case of just a regular citizen, a car owner, carelessly leaving the car, in the driveway with the keys. Like, who hasn't done that in the winter, started up the car, left it in the driveway for a few minutes, then come back out? The Court of Appeal for Ontario says you're probably not responsible in that case. There's some really kind of interesting and unusual facts here. This garage had a reputation as being a target for joyriders in the past. Cars had been stolen from there in the past, and they were very much in the practice of just simply leaving keys in the vehicle in plain sight with the doors unlocked overnight when it was known that there would be, teenagers drinking, doing drugs in the neighborhood. And the court recognizes that this is a dangerous situation. So, the argument's made to the Court of Appeal that there's a specter of unlimited liability here. It's the floodgates argument. Lawyers like to use that term. And the court says, no, it's not. We're not opening the floodgates here. For us to find, that the garage owner discharged a duty would not take much. It would simply require, for example, the garage owner to use a lockbox. Like, think about it when you're taking your car in for repairs. If you show up, with your car early in the morning before they're open, most places have those boxes where you can drop the keys, along with your documents or whatever in the box. The keys go in the box just like a safe. And a person can't take the keys out of there. So, they didn't implement such basic measures as that at this garage. So what the court is saying is we're not imposing a lot of hardship on people who run businesses. We simply need people to take care. You must take reasonable care, that people are not exposed to danger as a result of your actions. You're not obliged to take every conceivable step or every expensive step, but you have to take reasonable steps.
Sure, but the part that I have to come back to, Nick, is the only reason these young boys were in any danger is because they stole the car. The car wasn't presenting any danger whatsoever sitting there in the lot.
Yeah, and I think that is true, and I agree with you, and I accept that is going to not sit well with a lot of people, when they hear about this case. Extenuating circumstances are the plaintiff was only 15, he's a kid, and he was, I think it is interesting to note, he was not the driver of the car. He was a passenger. What we gather from the written decision is he's kind of along for the ride, but it's the other kid who steals the car and is driving it. Interestingly, there were multiple defendants. My take on this is that there was, probably the car that was stolen, like I say, may have had a $200,000 limit of liability insurance. Terribly inadequate for a severely brain-injured individual. And then there's a couple of uninsured defendants. One of those defendants is the mother of the driver, who's referred to as DC in the decision, who was plying these young men with alcohol and had bought them a case of 2-4, during their escapades before they stole the car. So that's obviously grossly irresponsible on the part of that individual. But there's no insurance, presumably, that responds to it. So, it's unfortunate. A lot of people are going to look at this as this plaintiff is the author of his own misfortune. There is some element of that to this. The garage was found to be responsible to the tune of 37%. Don't ask me how that kind of split on the damages is arrived at. I don't know. It seems arbitrary to me, but the garage was not found to be 100% responsible. It's found to be 37% responsible. I don't know where the 37 comes from, but It's not the major part of the fault, though.
But in the breakdown, then I think that mother you just referred to is a 30% responsibility, so not entirely responsible is the garage, not entirely responsible is the mother, but they share the burden of responsibility with the 16-year-old, as I understand, that drove the car too.
That's right, 23% for the driver. Yeah, and again, think about it this way: how would we look at this differently? And would we have less sympathy for the garage owner if, say, these young men hit an innocent pedestrian, child, adult, whatever, on the road crossing the street? Then you have kind of a similar argument, but you don't have that element of, the plaintiff being the author of his or her own misfortune. So, in that scenario, should the garage be responsible? And I think it's more evident and more sympathetic, that the garage would be in the circumstances of this case. At the end of the day, it's a very sad case, very unusual, and even the Court of Appeal's own decision says, look, the circumstances in which a person may try to fit into this ruling are going to be very rare. It's going to be very unusual where we're going to find someone with the care and custody of a vehicle and that vehicle stolen, that person's responsible for somebody's injuries.
Yeah. Nick, you've explained it extremely well. Thanks so much for the time and the expertise today.
It was my pleasure. Thank you for having me on your show.
Bye-bye.
Bye-bye.
Nick de Koning, he's with Deutschmann Law here in town.